Welcome back to the Constitutional Clarion. This video is about the lobbying of members of the Commonwealth Parliament and access to them with parliamentary passes. Now, it's been sparked by a Senate committee which is currently inquiring into the issue. Lobbying itself, while it does tend to get a rather bad reputation at times, is not necessarily a bad thing. It's a way that groups can inform ministers and parliamentarians, such as crossbenchers who hold the balance of power in the Senate, about issues that affect them and about their perspectives, which may not otherwise be apparent to members of Parliament. All of us do tend to live in our own separate worlds, our own silos, and we do tend to find it difficult to see things through other people's eyes, and particularly where a problem affects a particular group of people and we may not understand how it does affect them. So lobbying is a means by which political decision makers can come to better informed decisions about the different needs and perspectives of people. But lobbying can also be a means of exercising undue influence over politicians and can potentially lead to corruption. Now, this is especially so when lobbyists represent rich and powerful interests which can profit greatly from government decision making. They may seek to influence politicians through, for example, making significant political donations or offering potential employment in the future to politicians or their staff once their political career is ended. Now, we've all heard the stories about this, and we do have good reason to be concerned about these types of practices. This is why it's really important that there are appropriate measures in place to protect government integrity and public trust in the system of government. There needs to be regulation of lobbyists, transparency about their operations, and equal opportunity to have access to members of Parliament, to those who are in power. Now, currently there is a register for lobbyists and there is a lobbying code of conduct. But somewhat bizarrely, both of these only apply to professional lobbyists who act on behalf of third parties. It doesn't cover most lobbyists who are in-house lobbyists for big corporations or who are lobbyists for peak bodies and various sectors in society. The consequence is that most lobbyists aren't actually covered by these laws. Indeed, I saw one lobbyist quoted the other day in the press saying in rather outraged terms that they were not a lobbyist because they don't fall within the definition in the legislation. Well, the answer there is that this is because the definition is completely inadequate. It's not because they're not a lobbyist. Okay, so let's talk a little bit here about the Lobbying Code of Conduct. The preamble to the Code of Conduct stresses the importance of lobbying activities being carried out ethically and transparently. It says that the code is intended to promote trust in the integrity of government processes, which is a good thing. But how can that trust exist if most lobbyists are not covered? More specifically, the Lobbying Code of Conduct says in Clause 12 that a lobbyist must not engage in any conduct that is corrupt, dishonest, or illegal, or unlawfully cause or threaten any detriment to a person. The lobbyist must use all reasonable endeavours to satisfy themselves of the truth and accuracy of all the statements and information that they provide to government representatives. And when making initial contact with a government representative with the intention of conducting lobbying, the lobbyist must inform the government representative whether they are on the register of lobbyists and for whom they are conducting the lobbying activities. Now again, one has to wonder why this only applies to lobbyists with third-party clients. Are we really saying that it's okay for in-house lobbyists to be dishonest, corrupt, and to lie and to deceive members of parliament and ministers? Don't really think so. So, what does all this have to do with the issue about parliamentary passes? Well, some lobbyists are given what are known as orange passes, orange sponsored passes. So orange is just the colour of them. And they're sponsored passes, meaning that you only need one member of parliament to sign a form to sponsor you to get one of these passes. And quite a lot of lobbyists do have these passes. Now, having one of them allows the holder full access to the non-public areas of Parliament House in Canberra. So they can just stroll around the corridors, do drop-ins in various offices of ministers and parliamentarians without having an appointment. They can hang out at Aussie's, the coffee shop in Parliament House, and they can accidentally run into the members of parliament that they want to lobby, or they can even lurk around in the public areas outside the chamber after a division and catch a politician going past. So what this does is it allows lobbying to occur in an informal and undocumented way, without any kind of formal appointment being recorded in a diary, and without the attendance or knowledge of a staffer or an official. In short, it opens up the door to undue influence and potentially corrupt behaviour. Having a system that actually opens up such opportunities is, in my view at least, unwise and inappropriate. Now, from a legal perspective, in a case called McCloy in New South Wales, which concerned political donations, the High Court referred to what it called the great underlying principle of the Constitution, that the rights of individuals are secured by ensuring that each has an equal share in political power. Now, 4 of the judges, when discussing that, referred to a parliamentary committee report which had acknowledged that the purchase of access to politicians through making large political donations, which is not available to ordinary citizens, can result in actual or the perception of undue influence. And that report said that, well, reform was needed to, quote, restore public confidence in the integrity of the system. Now, their honours went on to state that equality of opportunity to participate in the exercise of parliamentary sovereignty is an aspect of representative democracy which is guaranteed by our Constitution. They went on to note that a law had previously been struck down by the High Court because it was inimical to equal participation by all the people in the political process, which was fatal to its validity. They pointed to the risk to equal participation that is posed by the uncontrolled use of wealth. In this case, it was the use of wealth to make political donations that could then buy access to politicians that others did not have. Now, Justice Gageler said that the influence which comes from the preferential access to government resulting from the making of political donations does not necessarily equate to corruption. But he did recognise that the line is not always easy to discern. He concluded that the elimination of preferential access to government is a compelling legislative objective. In practice, those who have unlimited access to the non-public areas in Parliament House do have preferential access to political decision makers, to ministers and members of Parliament. Their lobbying is not transparent because it occurs informally, without there being an appointment or a record of the discussion. And it's potentially a breeding ground for corruption and is inimical, as the High Court would say, to the constitutional principle of equal participation by all the people in the political process. Lobbyists, whether they be in-house lobbyists or professional lobbyists for third parties, should have to make an appointment to see ministers or other members of parliament like crossbenchers. They should have to do so like anyone else. Those appointments should be transparent and should be published, just as they do in New South Wales, where they publish ministerial diaries. If a lobbyist has an appointment in Parliament House, they should be given an escorted visitor's pass, just like everyone else. And finally, the Lobbying Code of Conduct and the Lobbyists Register should apply to all persons who are paid to lobby governments or parliamentarians on behalf of their employer or its clients. There's no good reason why some are subject to ethical obligations and transparency requirements while others are not. Now, if we manage to achieve this, it would be at least a start on the road to genuine equality of participation in the political process. However, keep an eye out for the committee's report and let's see whether the lobbyists themselves are sufficiently successful in lobbying the committee not to make any reforms. That remains to be seen. So thank you for watching the Constitutional Clarion. I again hope you found it interesting and I'll see you next time. Goodbye.